before we bring the jury in, Mr. Grinke?
I'll just let you know it's going to be a short day. Well before lunch, we will be done.
Okay.
And Your Honor, I would move that Exhibit 50 be admitted into evidence. It was the PowerPoint that was gone over by the FBI agent.
It was by Ms. Abbott, or it was
Ms.
Ms.
Otterstader.
Otterstader. No objection.
All right. That'll be received. Anything, Mr. Zacher, at all? I didn't ask you if there was anything we need to talk about.
No, Your Honor.
Okay. Do you guys need the screen this morning?
I don't think I will.
I don't think so, Judge.
Okay. All right, let's bring the jury in then. Everybody may be seated. Good morning, ladies and gentlemen. I have some good news, which is we don't think this is going to go beyond lunch today, which means you'll get Friday afternoon off at least, unless you have to run back and do work or something in between. So we'll start up. Again, if there's anything, we'll talk a little bit before you leave about Monday morning. One other thing I just wanted to talk about because it's sort of fresh in my mind. I know there was, I have been told there's some concerns if people recognize you. They shouldn't be because you haven't been on TV. There was one moment where you were, by the way, but they have corrected that and they've taken it off the internet. There was one accidental entrance into the jury room, but the media took care of that right away and they got rid of it. But if that does happen, remember, you can very easily say, I can't talk about this. I've been ordered not to talk about it. You can, again, blame it on me. I'm fine with that if it's friends and family. I know it's very tempting, but it's just one of those things. You'll get an opportunity once this is all over. So, all right, we'll get started. Mr. Grinke, call your next witness.
State calls Chief Boudreaux.
Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? Thank you. Have a seat, please.
Could you state your name?
Sean Kudron.
How are you employed?
Currently, I'm the Chief of Police for the La Crosse Police Department.
And prior to that position, what was your occupation?
I served as the captain of the Investigative Services Bureau.
How long you were captain of that bureau?
I was captain for approximately 8 years. A little over 6 years of that was with the Investigative Bureau.
How many investigators did you oversee?
Approximately 12.
And turning to the case that we're involved in this week, were you responsible for the ultimate decisions in this case?
Yes. My responsibility was to oversee the investigation, to assist in guiding the investigation, and to make decisions on how the investigation would occur.
How do you assign investigators to a case like this?
So Originally, or at least to start, this report was taken by our police department as a missing persons report. All missing persons reports are assigned to an investigator to investigate, to look into. This report was also assigned in the same manner when it came into our bureau.
As the case develops, how do you decide to assign more investigators or not?
Once we start to learn additional information about the specific case, and it's in this case that there were items left behind in Aaron Sambalai's house. People were contacted, family members who had not seen Aaron. And we also received information from Erik Sackett that we needed to confirm because we were unsure if it was truthful. We began to assign additional investigators to start gathering additional information about the whereabouts of Ms. Sambalai.
As this process is going on, are there other cases coming into the Bureau?
Yes. On a daily basis, our patrol officers are responding to calls for service. They're generating reports, and many of those reports need additional follow-up. As part of my responsibilities as the captain of the investigative bureaus, I review all of those reports on a daily basis. Along with this investigation, as additional reports were coming in for different types of calls, burglaries, hit and runs, sexual assaults, I would review those cases and determine if they needed additional follow-up, and then assign investigators to work on those cases as well.
Any idea how many cases you're getting in on a daily basis?
Well, it really depends on the time of the week. Certainly after a weekend, there can be upwards of 60 to 70 reports that need to be reviewed. On a normal day, typically during the week, we would review anywhere from 20 to 30.
There's been some questions in this case about investigators and the scene at 435 Rose Street. Is it possible in every missing person case to treat it as a homicide from day one?
No, it's not.
Why is that?
The vast majority of missing persons cases that we take, which could be anywhere from 15 to 20 a month, the vast majority of those individuals either return or are found and aren't treated immediately as a homicide.
Is homicide or suicide always a possibility?
Yes.
When is a decision made whether or not to treat a scene as a crime scene or not? In terms of holding it from family members and holding it from the public and closing it off from access?
It really is very dependent upon the type of case that we're working. On a regular basis, working a missing persons case, you would not immediately hold the scene or the house or the apartment. As information is developed, it becomes important to try and understand what type of information we need to gather from the scene, or to try and determine did a crime actually occur at the residence or apartment where the missing person had lived. That can take several days before we understand that, or even up to several weeks, depending on the specifics of the case.
If it's later found that a homicide occurred, could that result in the loss of evidence?
Yes, it could.
In developing the process of investigating a missing person case, do you develop a list of people to talk to?
Yes, we do.
How do you determine which people to talk to?
In investigating a case, missing persons case, we start first with the people that are closest to the individual who's missing, family members, friends, people that they've been in relationships with. And that's where we start in terms of trying to gather information about the missing person about habits, about their lifestyle, about people that they come in contact with, about their typical schedule, and essentially how they go about their life.
There's been some talk about the term suspect and person of interest. Is there a formal designation when you're dealing with people in an investigation, whether they're a suspect, person of interest, or some other term?
No, there's not. The terms are used in different ways with investigators. And in looking at cases and developing cases, I do not have a formal designation or a checklist to go through before I determine how to refer to somebody that we are essentially investigating or trying to develop information on, and label them as a term as suspect or person of interest.
You talked about looking at a person's relationships with family members and people they're in relationships with. Do you look for patterns and breaks in patterns?
Yes. We look at basically how this individual is living their life, the people who are around them and that are close to them, what their typical patterns would be in their life, what a typical day looks like for the individual who's missing, as well as the people who are close to them, what their typical day looks like, what their habits might be. And investigators are looking for any breaks in those habits, breaks in what that typical day might look like. And if there is information that's obtained or uncovered that shows a break in certain habits, we look into that further to try and find out what that might potentially mean.
In a missing person investigation, how do you determine where to look in terms of location?
Well, it becomes difficult. We first, again, talk with many people who are close to them. We also look at electronic devices that they utilize to see where they might have been, if those electronic devices are available and if that information is available. We also look at video surveillance, video footage that might show us somebody that is coming and going, let's say, from their residence, or maybe a place where they were in public, maybe a place where they were shopping, or some other camera that we may have within the city of La Crosse that might capture footage of that individual or potentially somebody close to them that might help us develop information as to their whereabouts or their activity.
You mentioned surveillance video. Is it fair to say there's a lot of surveillance video these days?
Yes, there is.
And what's the process of trying to get surveillance video and deciding where to get it and how much to watch?
Yes. So the process can become a bit difficult because there are a lot of surveillance video cameras these days. The first thing that we do have to try and do is locate where those cameras might be. We have obviously officers and investigators who are working cases on a regular basis and may develop locations of where cameras might be, so there may be some general knowledge of that. Otherwise, we have to go and look. We have to canvass and look for cameras in residential areas, as well as stop at businesses to find out what type of cameras they might have or maybe have installed. And then once we find those, we have to find out the type of system that they have, when it records, if it records. And once we know that, we have to determine which cameras might actually obtain information for us to look at. And then we have to essentially go through the process with that system of trying to download that video. We typically have some type of device that we can download it on, flash drive type device, where we can then bring that back to the police department and begin looking at it or observing what's on the video. This can be a bit of a daunting task because many times we don't have the ability to speed up the video, and so we have to watch it essentially in real time or minute for minute, and that can certainly take quite a bit of time in trying to figure out what we're looking for. So as we're developing information, we're trying to figure out timelines so that we can essentially have a start on that video to know kind of where to start and what to look for.
When you were looking at that surveillance video early in the investigation, before Erin's body was found on June 17th, did you have any information that she had been to Vernon County earlier in the day?
No, we did not.
Did police do anything to try to invite members of the public to give information?
Yes, we did. Our investigative division had put out some information in Vernon County eventually to try and find if there was additional information. We had also put out information on the case, and there was quite a bit of social media information that was generated from family members and friends that was also available and letting the general public and people know that Ms. Samvalai was missing.
In this case, there were search warrants performed and executed by members of the Detective Bureau. Other times, things were done by consent or without search warrants. Is there a reason why sometimes search warrants are used?
Yes. Many times, we have the ability to apply for a search warrant through the court, and then that gives us the ability to search a certain residence. Due to privacy concerns, we are not always knowing who exactly lives in certain places. The search warrant allows us to, in the cleanest manner possible, enter a residence and search it to try and obtain information or evidence for a case. That is the typical reason then that we would apply for a search warrant in any case to essentially try and find additional information.
You're aware that on June 7th of 2018, a search warrant was conducted at Mr. Sackett's residence?
That's correct.
And instead of asking consent, why would a search warrant have been done rather than just asking to go in and look for things?
At that particular time, there was some information that we knew that we were unsure if Mr. Sackett had been completely truthful with our officers on the initial contact that was had with him. We were also unsure of exactly who all lived at the house that Mr. Sackett resided at. Based on that information, the decision was made to get a search warrant to again apply to the court with the information that we had so that we could obtain a search warrant to then go in and look for additional information in trying to locate Erin.
You're aware that Dr. Ansrud was named as a potential suspect in the case as well?
Yes, correct.
And on June 8th, he was spoken to and his house was searched, but not with a search warrant. Was there a reason for that?
Yes. At that point in time in the investigation, we had developed information that Ms. Samvalai had connections with Dr. Ansrud. We made contact with Dr. Ansrud on the 8th. Information up until that point was that she had a professional relationship with Dr. Ansrud, and our investigators contacted him to discuss the circumstances of their contact together. At that point in time, investigators' main purpose was to try and locate Erin, and after the conversation with Dr. Ansrud at his place of work, they asked for consent so that they could look through his house to make sure, to see if Erin was there. This was done in a timely manner. Due to the professional relationship with Erin, we didn't know anything further at that point. Investigators went to his house in a short amount of time after the contact with him and looked through the house and the garage to see if Erin was there.
Do you know how many times somebody in your investigative bureau spoke with Dr. Ansrud?
I believe he was spoken to at least 4 different times.
Did he always agree to an interview?
Yes, he did.
Did you ever develop any information that he lied about his whereabouts on June 3rd or June 4th?
We developed no information that he had provided false or untruthful information about his whereabouts.
Judge, objection, hearsay, calls for speculation, legal conclusion, move to strike.
Sustain, struck. Go ahead.
Did you try to develop a timeline for Dr. Onsrud, as you did with other witnesses?
Yes, we did.
Did investigators find any evidence of any angry interactions between Dr. Onsrud and Aaron?
No, we did not.
Was there any evidence located that did not fit Dr. Onsrud timeline?
No, there was not.
Did you check the information he gave you to try to corroborate his information?
Yes, we did. We had learned information that Dr. Onsrud was at June Dairy Days in West Salem, Wisconsin on June 3rd. We spoke with an acquaintance of his who was also at June Dairy Days, who indicated that he did have contact with Dr. Onsrud.
Objection, hearsay, move to strike.
Sustain, struck.
Without saying what they said, were other people spoken to about Dr. Onsrud's whereabouts?
Yes, they were.
Anybody else? Any of his family members?
Yes, a member of his family was spoken to.
Did you eventually get copies of his work records?
Yes, we did.
The crime lab evidence was talked about in this case, and there were two crime labs involved, the state of Wisconsin crime lab and also the FBI lab. Was there a decision made to not test the hairs that were found for DNA?
Yes, there was.
And why was that?
We had contact with the FBI crime lab regarding the hairs that were located during their analysis of items that we had submitted to them, which was chain and rope. During that analysis, they indicated that they had located hairs. We then took basically the next step and obtained hairs from Mr. Sackett to send in for additional analysis. We also had hair that was recovered at the time when Aaron's body was found that we believed potentially came from her head, and we sent those hairs in as well. After the analysis was completed, the FBI lab analyst had a conversation with me to indicate what their general protocol was based on the analysis of that hair and the fact that Mr. Sackett's hair samples did not match the hairs that they had found on the chain. They had indicated that they had a scientific explanation that the hairs were similar to Miss Envolay's. Based on that information, it was their protocol not to continue to do additional DNA testing, and we did not have other sample hairs for comparison. In consultation with the FBI lab, that decision was made then not to do further DNA testing on the hairs that were located.
Turning then to the state crime lab, the pickup truck that was normally driven by Mr. Sackett was taken down to the crime lab in Madison.
That's correct.
And at that time, the crime lab in Madison did not take any swabs from DNA from the truck.
Objection, hearsay.
Sustain.
There was a question asked earlier as to why the decisions were made not to swab for DNA. Is that a decision that would have come from you?
Never mind. Withdrawn.
It was not solely my decision.
Who else was involved in that decision?
Members of the Wisconsin State Crime Lab.
And why was the decision made not to ask for DNA swabs from the back of the truck?
When discussing the potential evidence recovery of DNA from the back of the truck, members of the Wisconsin State Crime Lab who were overseeing the evidence collection of the truck had noted several different pieces of information that led them not to do additional DNA analysis. The fact that the truck in and of itself, that the open bed of the truck had been exposed to the elements for several days by the time that truck had went to the crime lab, and the fact that we did not have specific information on the exact location within the bed of the truck that DNA would be sought. It was their protocol to not arbitrarily decide where to swab or try and collect DNA. They also indicated that it's not their practice to try and locate DNA in every square inch of the back of the truck. Based on that information, I had asked them if there was basically any possibility within their protocol to choose certain areas, and they indicated that is not something that they do based on all the circumstances of the case and the timing of the truck being brought to the crime lab.
There was earlier a question about what vehicle Ms. Samvalai drove to Quick Trip on the morning of June 3rd. Were you able to review the video from the Quick Trip that morning?
I was able to review the video.
And were you able to determine which vehicle Ms. Samvalai drove to that Quick Trip on June 3rd in the morning?
Yes, at approximately 9:35, I observed in the video her operating the maroon Cadillac CTS. Within the video, you're able to see that vehicle backing out of a parking spot.
When you look back at investigations, do you find problems within investigations?
Yes,
Are there problems with individual officers within the investigations as well?
at times.
In this case, looking back, were there mistakes made in this case or things that could have been done better?
Yes, every time we look back on a case, hindsight, so to speak, on a case where you know information and now you're looking back over the course of the case, we certainly find areas where we would then, if we knew that at the time, would want to do things different. For instance,
Objection, non-responsive.
Ask another question.
Yeah. What things in this case did you determine could have done better or different?
we discussed the holding of the residents and being able to have the Wisconsin State Crime Lab come to the residents sooner to do a forensic analysis of the residents. Knowing what we know now, doing that sooner may potentially uncover additional information.
Is there such a thing as a perfect investigation?
No, there's not.
That's all I have, Your Honor.
Crosse?
Thank you. Morning, Chief.
Morning.
Alrighty. You ready?
I think so.
Okay. So, numerous investigators in this case have testified that you were the person who was ultimately in charge of this investigation. Do you agree with that?
Yes, I do.
And in that capacity, were you reviewing all of the information coming in about Ms. Samvalai's disappearance and death?
Yes. So information that was coming in, such as reports, as well as information that was gathered by investigators. There was verbal contact that we were having with each other as the investigation was occurring.
Did you review every report that came in?
I did, yes.
And you do that because you need to have somebody in the investigation who is aware of what every single moving part is doing, right?
Yes, that's correct. It's important to have a basic understanding of what each report is saying, and being able to have a conversation with the investigators as they're completing their reports, as well as have somebody that is essentially being able to take the reports in, and we have a reporting process of how it goes through to our records staff, and somebody needs to coordinate that process as well, and that was my responsibility.
Essentially, you need a head coach calling the shots on what to do next in the investigation, right?
That's correct.
And that person was you.
That's correct.
And you agree with me that investigations should be thorough?
Yes, they should be.
That the facts gathered should be accurate?
correct.
And that to the extent that there are multiple leads, that all of those leads should be followed up on.
Yes, they should be looked into.
Do you agree that if there are multiple suspects, each suspect should be investigated?
Yes,
Because sometimes investigators make assumptions, right?
it's possible.
Do you agree that in your line of work, it's important to try and avoid making assumptions?
It's important to try to avoid to make assumptions, and that is why we would brief on the case so that we had as many perspectives as possible when information was being gathered.
Let's talk about these briefings. Are you and the investigators involved in this case gathering in a room and discussing what you found individually?
That's correct.
And the purpose of that is to keep everyone apprised of what everyone else is doing. Is that correct?
Yes,
Because you don't want one investigator coming in with a different perception of the case as another one, right?
it's important that information is shared so that all investigators are essentially understanding what's happening as other investigators are going out into the field and gathering information. The briefings would allow us to do that.
And you trust your investigators, right?
I do.
You trust them to act independently, right?
Yes, they have an obligation to act independently at times, but
And-
also to work with other investigators to gather information.
And your job, Chief Kudron, is not to micromanage the details of an investigation, right?
Not to micromanage, no.
In fact, in most investigations, you're not personally involved at all. Is that correct?
That is correct. I have a position where I'm reviewing information, but not actually out doing the interviews or gathering the information or gathering the evidence.
And do you agree with me that a good investigator should not be afraid of facts that turn out to be inconsistent with his or her own working theory of the case?
It's important for investigators to gather facts and to use those facts to try and to determine the truth.
You're familiar with the term tunnel vision or confirmation bias?
I am, yes.
Both terms?
Yes, more so tunnel vision.
And what does that mean to you?
Tunnel vision would simply mean that somebody is essentially maybe identifying a path that they believe the investigation is going to take and that they are not looking at other factors.
Do you agree that police officers, like everyone else, is human and subject to sometimes experiencing tunnel vision?
It's possible.
You agree that tunnel vision can and does occur among police investigators?
It's possible.
And you talked a little bit about what led you to Mr. Sackett initially. And Mr. Greenke asked you and you responded that breaks in habits could be evidence of who to look for. Is that correct?
It's correct that breaks in habits are important to understand and to develop information or understand if you're seeing breaks in certain habits.
A break in habit could also be something entirely innocuous, right?
It's possible.
And one of the dangers in looking at breaks in habits as evidence is that an investigator might form an impression that that person is acting suspiciously, correct?
They might form an impression, or they might just gather that information and keep it in their mind as to how it relates to the investigation.
All right. Now, let's talk a little bit about how that applies to Dr. Ronsrud. You agree that Dr. Ronsrud was treated as a person of interest in this investigation?
Yes, I do.
And not every single witness or person that investigators interacted with received that title. Is that correct?
Not every single person, no.
And your testimony initially was that Dr. Ronsrud had what you described as a professional relationship with Ms. Sambalai, and that's what you were aware of on June 8th?
That's what was related, yes.
Did you assign any particular investigators to interview Dr. Ronsrud?
Yes, I did.
And that was Lieutenant Mike Blockheis and investigator Andrew Rosenau?
That's correct.
And did you review that interview at all?
At one point in time, I would have reviewed that interview.
Did you watch the actual recorded interview?
No, I did not.
Did you review the police report of that interview?
Yes, that's what I mentioned that I would have reviewed.
And you're aware that during that interview on June 8th, Investigator Rosenau and Lieutenant Blockheis confronted Dr. Ansrud about the nature of his relationship with Aaron.
Objection, hearsay.
May we approach?
You may.
Okay. Chief Kudron, you're aware that on June 8th, when Investigator Rosenau and Lieutenant Blockheis interviewed Dr. Ansrud, that they confronted him about the nature of his relationship with Ms. Samblai.
Yes, I believe they asked if there was more to his relationship.
Indicated to him that they had indeed received more information about that,
I believe Lieutenant Blockheis had questioned him regarding that.
and they wouldn't know to ask about that unless they knew before the June 8th interview that there was more than a professional relationship.
Lieutenant Blockheis may have asked him a question in that manner to try and find out if there was additional information that could be provided, something that we didn't know. It may have been an investigative technique that Lieutenant Blockheis was using to find out if there was more information.
You aware of how long this interview was?
I'm not aware of the exact duration.
And you aware of what portion of the interview was devoted to Lieutenant Blockheis and Investigator Rosenau questioning Dr. Ansrud about the nature of his relationship with Ms. Samblai?
I'm not aware of the exact point in time during the interview that was asked.
You agree that it was a significant portion of the interview?
Objection, asked and answered.
Overruled.
I can't agree to that. I don't know if it was a significant portion of the interview.
You haven't actually watched the interview?
I believe I answered that I have not watched the interview.
You aware that it was recorded on body camera?
Objection, asked and answered.
It's essentially answered.
Okay.
He knows it's recorded, so he's said that.
And your testimony initially was that Mr. Sackett received a search warrant for one reason, that investigators were concerned about the truthfulness of some of the information that was provided. Is that correct?
That's correct.
You agree that there was a concern with some of the truthfulness of the information that Dr. Ansrud provided?
We were attempting to see if there was additional information that could have been provided from Dr. Ansrud, not necessarily that it was untruthful at that time.
And your testimony was that Mr. Sackett was, or that the persons who resided at Oak Drive were unknown, and that's one of the reasons why you sought out a search warrant for Mr. Sackett and not Dr. Ansrud?
Could you re-ask that question,
Sure.
please?
You testified that the residents of Oak Drive were unknown, and that was one reason for seeking out a search warrant for Mr. Sackett's residence on June 7th.
Yes, we were unsure of exactly who all resided at the residence.
A warrant is a document that you have to swear an oath to, similar to what you took here in court.
That's correct.
And obviously, investigators are expected to tell the truth when they swear that oath in pursuit of a search warrant.
Yes.
Okay. Get an exhibit marked, please.
Exhibit 564.
Chief Kudron, I'm showing you what's been marked as is Exhibit 564, which appears to be a search warrant signed by Judge Gloria Doyle on June 7th of 2018. Do you recognize that document?
Yes, I do.
And does it indicate on the front that the person who is the subject of the warrant is Erik Sackett?
Yes, it mentions Erik Sackett's name and that the search warrant was for 2744 Oak Drive.
Does not mention any other person's name, is that correct?
No, it does not.
And that search warrant was served to the best of your knowledge, correct?
Correct.
Okay. I can take that back from you. Offer 564 for the purposes used.
No objection.
Okay. 564 we received.
You aware of how many search warrants were ultimately served at Mr. Sackett's home? Well, June 7th, right?
That's correct.
June 15th?
I believe that's correct.
June 17th?
Correct.
June 19th? Or June 18th, excuse me?
I'm not exactly sure about that exact date.
There was a warrant served subsequent to the June 17th warrant at Mr. Sackett's home.
Okay.
And that was the warrant in which blocks were seized, correct?
Yes, excuse me. Yes, correct.
So at least 4 search warrants at Mr. Sackett's
Yes,
home.
that's correct.
And at Ms. Sambalai's home, I counted June 7th, is that correct?
Correct.
June 17th,
Correct.
and I believe there was another warrant after that fact as well, correct?
I believe there was another warrant. Correct.
I don't have it right in front of me,
Sure.
but yeah. Now, how many search warrants were served at Dr. Onsard's home?
There was a consent search done.
And Investigator Rosenau testified to that as well. You're aware that there was a body camera made documenting that search?
Correct.
Did you view that body camera?
I did have an opportunity to view that.
You agree with me that the entirety of the walkthrough of Dr. Onsard's home took about 24 minutes?
That's possible. I don't know the exact duration, but that is possible.
If Investigator Rosenau testified to as much, do you have any reason to disagree with him?
I don't. No.
And Dr. Onsard's home appeared to be quite cluttered during that search warrant? Or during that consent search?
I don't know if I would personally describe it as quite cluttered.
You heard Investigator Rosenau say to himself or to somebody off camera that the place was disgusting?
I don't remember that specifically when I reviewed.
Okay. Would you agree with me that at that time they were simply looking for Aaron?
Yes.
Weren't looking for ropes?
Not at that time.
Weren't looking for blocks?
Not at that time.
Weren't looking for evidence of bondage or other sexual activities?
No.
And would you agree with me that 24 minutes is a very limited time to search a property the size of Dr. Onsard's?
In reviewing the video and reviewing how the investigators walked through the house, and they were looking in different areas at different times. They were looking for information that would provide additional information in terms of where Erin's her location would be at the time, to make sure that she was not there or there wasn't evidence that she would have been there. They were not searching the residence so that it would have been what you would call a more particular search in terms of looking in every drawer or every cabinet. So I believe the way they had gone through that search, the amount of time that it took them was appropriate.
And they wouldn't be looking for Erin at Dr. Onsard's home unless you had some reason to believe that Dr. Onsard was connected to her, right?
We wanted to look into every possibility.
And other than Mr. Sackett's home, Dr. Onsrud's was the only home in which investigators looked for Ms. Sambalai. Is that correct?
We looked at Ms. Sambalai's home or apartment as well.
Okay. So other than Ms. Sambalai and Mr. Sackett's, Dr. Onsrud's home was the only one in which investigators sought to look for her.
Correct.
And you covered this a little bit, but during that initial walkthrough,
Excuse
you
me.
good? During that walkthrough of Dr. Onsrud's house, they're not looking through drawers or storage spaces, right?
Correct.
Not looking in the closets.
I believe they may have. They may have opened up closet doors.
As opposed to a traditional search warrant where there would be a very close inspection of everything inside of the house.
Correct.
And that was never done at Dr. Onsrud's home, correct?
Correct.
There was never any search for ropes or blocks, right?
That's correct. There was
Thank you.
not information developed that would have led investigators
Thank you.
to have the need to do that.
Now, you're aware of the fact that bondage equipment was eventually photographed by investigators at Dr. Onsrud's home.
Correct.
You're aware that not all of the equipment that Dr. Onsrud described to investigators was provided to them.
I'm aware that there was a certain type of rope that was provided to to Lieutenant Blockheis.
And investigators took Dr. Onsrud at his word that that was all he had, correct?
That's correct.
You're aware that Dr. Onsrud described more than just a couple of pieces of ropes and handcuffs to investigator Rosenau when he admitted to the bondage activity?
I'm object to hearsay again.
It's a predicate question as to why there wasn't follow-up.
Still
Was it
hearsay.
not being, I know this has been testimony from before anyway, but it's not being offered for the truth of the matter, then it's just to get to the issue of what you want to get to.
Sure.
And I'll allow the question for that basis.
To my knowledge, there was also information regarding some type of, and I probably won't describe this quite correctly, but some type of wrist, something that may have gone around his wrist. They may have been described as like leather or something along those lines.
Okay. And various other items beyond that.
To my knowledge, there were not various other items.
Nipple clamps.
Yes.
A collar.
I'm not sure to a collar, but I do remember nipple clamps being mentioned.
And it was indicated that these were stored in a central location in what he called his bondage bag. Is that correct?
I remember that there was a description of a bondage bag.
And did it concern you that Dr. Onsrud only provided 2 of the items despite describing more?
It was, when we approached Dr. Onsrud, the rope was specific to what Lieutenant Blockheis was looking for.
And there was no effort to seek out a search warrant to get the rest of the items that he had described but were not disclosed?
No, there was not.
And there was no effort to clarify why those items came from his bedroom instead of the basement as he had described to investigators?
No, there was not.
And you described talking to a witness about June Dairy Days. Is that correct?
That's correct.
That's in West Salem, right?
Correct.
And you agree with me that June Dairy Days doesn't go all night long?
It does not.
And that was just June 3rd, right?
That's correct.
Dr. Onsrud was not asked about his whereabouts in the evening of June 4th. Is that correct?
We discussed with Dr. Onsrud what his activities would have been on June 4th regarding his regular work schedule, and information was obtained that he had checked into work on June 4th.
I'm asking about the evening of June 4th.
Not the evening.
Okay. You are aware that Dr. Onsrud was not present at work on Tuesday, June 5th?
Objection, Your Honor. Calls for speculation and hearsay. He wasn't scheduled to work on Tuesday. There's no evidence of that.
Rephrase the question.
You're aware that Dr. Ronser did not work on Tuesday, June 5th?
I'm aware of that.
And you agree with me that Dr. Ronser was not asked for his whereabouts on that date?
I am aware of that. Based on the investigation
Thank
and based
you.
on what we know, we were
Chief,
not.
Thank you. All right. Were you in communication with Dr. Ross Reichard's office?
Yes, I was.
Were you the main point of contact between the investigators and Dr. Reichard?
I was at certain points in time within the investigation, yes.
How many times?
I had spoken with Dr. Reichard on the phone, I believe personally 2 different times. I also was a part of a meeting with Dr. Reichard in Rochester at his place of work 2 different times as well.
And you provided information to Dr. Reichard about the scene of where Ms. Sanvalai was found. Is that correct?
That's correct.
And you provided that information to him because you felt that it was relevant. Is that correct?
Typically in a death investigation, when we have a body that's taken for autopsy, we try to provide information to the pathologist based on where the body was found, how it looked, pictures that were taken for the pathologist for additional information for them to complete their examination.
And you had multiple follow-up contacts with Dr. Reichard. Was that to communicate about the state of the investigation?
We had discussed different pieces of the investigation as well as timeline.
And would you agree with me that it's important for Dr. Reichard to have a complete picture of a decedent's life?
It's important for information to be shared with the pathologist. On a typical basis in a death investigation, the entire investigation is not consulted or shared with the pathologist.
Okay. My question was, is it or is it not important for a pathologist to have a complete picture of a decedent's state of mind?
Did you say state of mind or did you say her life?
Her life, excuse me.
Well, it's important to provide facts to pathologists, to provide every piece of information about the decedent's life would be probably, I probably wouldn't be able to do that.
Would you agree with me that it's important to provide information to the pathologist about the decedent's state of mind?
That would be important, correct?
And I assume that you're well aware from coordinating this investigation that Ms. Sanvalai had repeatedly expressed suicidal ideation in the days leading to her disappearance.
Yes, I'm aware of that.
You agree with me that not all of that information was shared with Dr. Reichard's office?
Not every piece of information was shared with Dr. Reichard's office.
And the fact that there was an alternate person of interest in the form of Dr. Ansud, that also was not shared with Dr. Reichard?
I'm not sure if that's completely accurate.
You're aware that he testified yesterday?
I am.
You're aware that he testified that he had no idea about that?
I'm not aware of that. I didn't see his testimony.
You continued to learn about acts in which Erin was acting either erratically or trying to hurt herself throughout the course of this investigation. Is that correct?
That's correct.
Would you agree that not all of those acts were shared with Dr. Reichard?
That's correct.
You agree with me? Let's talk about the DNA. In this case, what we were talking about at the State Crime Lab was the bed of a pickup truck. Is that correct?
That's correct.
And that's substantially smaller than asking the crime lab to sweep an entire home, right?
That's correct.
And in the past, you and your colleagues have asked for much larger sweeps of areas of DNA at certain crime scenes, correct?
We've asked the State Crime Lab to come to certain crime scenes and to provide a forensic examination of those crime scenes. Based on their expertise, they do make decisions on where to attempt to collect DNA.
Well, we had complete swabs throughout most of the Cass Street quick trip in Matrell Anderson's case. Is that correct?
Object to relevance.
Overruled. The issue of practice. Go ahead. Overruled.
There are DNA swabs taken during that case. Most of those DNA swabs were of visible blood that was observed in different areas within the quick trip during that investigation.
There were DNA swabs throughout the family photography store in the Jeffrey Lepsch case. Is that correct?
There were swabs taken during that investigation as well. The state crime lab was on scene. The number of swabs taken, where exactly they were taken from, I can't testify to at this point in time. I didn't prepare for testifying to that case.
And a DNA swab is simply rubbing what appears to be a Q-tip over a surface and preserving it for analysis. Is that correct?
That's correct.
Takes just a matter of seconds.
That's correct.
And if DNA doesn't pop up on an object, then that all you've lost is the time of conducting the swab and the test. Is that correct?
That's correct.
And in this case, the decision was made not to swab the bed of a pickup truck. Is that correct?
The decision was made by the crime lab. We consulted about it. I had made the request for it. Based on their protocols, they made the decision not to, based on the other factors that I had provided to you earlier.
You made that request because you felt that it could have provided relevant information, right?
Certainly possible.
And we don't have that information in this trial. Is that correct?
The crime lab had decided that they were not going to take swabs from the bed of the truck for the reasons that we had previously discussed.
Let's talk about mitochondrial DNA. You testified to some conversations with the FBI crime laboratory. Is that correct?
That's correct.
And they informed you in the letter that they sent to the La Crosse Police Department that a piece of hair can be tested for mitochondrial DNA. Is that correct?
Yes.
And the findings that you're aware of is that the hair found around the rope and the chain possibly could be Aaron's. Is that correct?
Correct.
But possibly, as they indicated to you, is not certainty. Correct?
That's correct, that they had indicated what they believed it certainly looked at based on class characteristics.
And mitochondrial DNA is used as a tool to include or rule out after visual inspection. Is that correct?
That's possible.
And mitochondrial DNA can tell us whether or not the person with the hair had the same mother or the same matrilineal line. Is that correct?
It's possible.
And you realize that Dr. Reichert took a DNA standard from Ms. Samvalai, right?
Correct.
That's standard in all autopsies, right?
That's correct.
And that standard could have been compared with hair for mitochondrial DNA testing if there was uncertainty about who it belonged to. Is that correct?
Could you rephrase that again?
Sure. That standard, the DNA standard for Ms. Samvalai, could have been compared to the question hair to determine whether or not they were similar after mitochondrial DNA analysis.
If the lab was willing to do it, it's possible.
You're saying that the lab wasn't willing to do it?
We had the discussion about the testing of the hair based upon the testing that they had done, the characteristics and what their standards were. That's how the decision was reached.
Okay. Let's talk a little bit more about the video evidence in this case. Erin was missing for a period of time between June 3rd and June 17 when she was found.
That's correct.
So a period of approximately 2 weeks.
Approximately.
And you have no idea after she was last seen what her movements were. Is that correct?
We were unsure of that, correct?
And during that time frame, you received reports indicating that Ms. Samvalai had possibly been seen alive. Is that correct?
We had received a report, correct?
And you received information from Mr. Sackett indicating that he believed that he had seen Erin alive and driving her red Cadillac, Cadillac.
Yeah,
Thank
He
you.
had made a comment to his girlfriend that there goes Aaron.
And those events occurred after the period of time in which your video surveillance had ceased. Is that correct?
Could you repeat that again, please?
Do you agree with me that video surveillance collected in this case effectively ends as of 8 a.m. on June 4th?
There was video surveillance concerning her residence, as well as the information we were able to find or uncover with Mr. Sackett's truck. And I believe that it was the morning of June 4th.
And if Investigator Pataska indicated that the cutoff time was 8 a.m., do you have any reason to disagree with her?
No, I do not.
And during this 2-week time frame, you agree that it would have been a matter of simply asking for or subpoenaing video surveillance in order to preserve additional footage.
So as we conducted the investigation and realized that there was no additional phone activity for Ms. Sanvalai,
Chief
no
Coudron,
additional
Chief
information that
Coudron.
was provided.
Just answer the question, please.
Yeah, you
Stick
agree.
to the questions.
It would have
Let's
been
get going.
it would have been easy to simply request the footage or to subpoena it, right?
Correct.
That's all you needed to do, correct?
If we decided to do that, that's how we would have gotten the video.
And you decided not to do that, right?
The choice was made not to do that based on all information we utilized at that point.
You decided to do that despite the fact that there were reports of Aaron being seen alive after the period of time in which your footage ended.
Correct.
And you decided not to seek out additional surveillance footage at the Vernon County focal points after the early morning of June 4th. Is that correct?
That's correct.
And you decided not to do that despite the fact that Mr. Sackett's truck was not identified in Coon Valley, Stoddard, or Chaseburg during the relevant time frame.
Correct.
Despite the fact that Mr. Sackett's truck was not identified at Enterprise Road and County Road O.
Correct.
Despite the fact that Mr. Sackett's truck was not identified on County Road Y.
I object to cumulative. This has all been testified to.
Move on.
Okay. And you agree it would have been easy to preserve that footage after the fact if you had chosen to do so?
If it was available, correct.
Did you make the decision to not report information about Dr. Ronzrud's behaviors to medical authorities or his employer?
Objection, relevance.
Sustain.
Was there a decision at some point in the investigation to try and protect Dr. Ronzrud as a potential witness?
No.
You're aware that Investigator Rosenau approached Dr. Ronzrud on August 27th and told him that the defense would be looking into his life?
Objection, hearsay.
Sustain.
At any point was Dr. Ronzrud's vehicle photographed for comparison to surveillance footage that you did have?
Photographed, I don't believe it was.
that would have been helpful to try to identify whether or not Dr. Onzer's vehicle was present or not at any of the video surveillance, correct?
Objection, Your Honor. A previous witness testified to this already.
All right, I'll give you a little leeway, but let's not go back to all the evidence that's been done before. Go ahead.
Do you agree that that would have been helpful for comparison purposes?
It could have been,
All of his vehicles, right?
correct?
And you agree that until this summer, nobody reviewed video surveillance, even looking for Dr. Onzer's vehicle?
Objection, Your Honor. That misstates Investigator Protaska's testimony.
Try to rephrase the question. I'm not sure what you're asking exactly.
There was a specific point in time in which Investigator Protaska was tasked to look for the presence or absence of Dr. Onzer's 2018 RAV4. Is that correct?
That's correct.
And that occurred at some point in the summer of 2019?
That's possible. I don't know the exact date that occurred, but that's possible.
Was that your determination as well?
It was a collective determination.
And that was limited to the videos that she testified to it, withdrawn. You testified that caseload is sometimes a concern when making determinations about what resources to devote to a case.
It can be, correct?
You agree that caseload is not an excuse for not conducting a thorough, accurate, and complete investigation?
Correct.
Thank you.
Redirect.
Chief Kudron, you were asked a question that you agreed that every suspect should be investigated.
Correct.
Was every suspect investigated in this case?
Yes.
Do you know about how many people were interviewed in this case by your bureau?
I would have to say hundreds of people were interviewed.
You were asked a question about tunnel vision. Do you remember that?
Yes, I do.
Is that a term that you're aware of?
Yes, it is.
Something you've talked about and trained about?
Yes, correct.
Is it something you watch for in your investigations?
It is.
You were shown an exhibit that was a copy of a search warrant for June 7th on Oak Drive. Do you remember that?
Yes.
Was there anything inaccurate on that warrant?
Not that I observed looking at it right now.
At the time, do you remember what information investigators had about who was present at 2744 Oak Drive that might have a privacy interest?
Yes, we were made aware that Erik Sackett potentially lived with his father.
Did you have information that he had a girlfriend, Kelly Melcheski?
Yes.
And were you aware of the nature of her privacy interest in that residence?
At that time, I was unsure if she resided there or not, or if she had taken up residence. We were unsure.
You asked about the length of time a search warrant might take. Does it depend what the search warrant is for?
Yes, it does.
Would a search warrant for a person take less than looking for a flash drive or traces of marijuana?
Yes, it would.
There's some questions about your conversations with Dr. Reichert. Do you believe you provided him all relevant information?
Yes, I do.
Was information provided to him about Aaron's suicidal state of mind?
Yes, it was.
Was every text or every detail about that shared?
No, it was not.
Why not?
In cases like this, and with the task that the pathologist has, we try to provide as much information as we can in terms of what we know about the decedent at that point. And that's a conversation that takes place with the pathologist where we're providing information and the pathologist is asking us questions.
Would it be possible to give a pathologist every report and every text from every person's life when they do an autopsy?
It would not be.
You were asked about swabbing of DNA. Have you done that before yourself?
I have.
And have you received training on collecting DNA evidence?
I have.
Is it relatively simple to take a swab of DNA from a visible blood drop?
Yes, it is.
What about a room where there isn't anything visible?
At that point, you're essentially just swabbing an area, not knowing if there's anything there to collect.
Do you have to take multiple swabs?
You would need to, yes.
Would each swab have to cover basically a square inch and document where that square inch is and not really see what you're swabbing?
Yes. So for something that would be described potentially as like touch DNA where you don't see it, you would have to swab an area and be able to document exactly where that area was and what was swabbed.
You were asked about some video evidence collection, and you testified that there was a comment from Erik to his girlfriend about something like, "There goes Aaron," or he saw Aaron's car.
Correct.
Do you know when that information came to police?
I believe that information came to police during an interview with Kelly Malszewski.
Do you know when that was?
It was likely after June 17th.
Were all possible sightings of Aaron by the public followed up on?
They were.
Were any deemed credible?
Objection, calls for legal conclusion, speculation.
I agree. Sustained.
Did any of them result in information that you felt could be followed up on?
We did not develop additional information to show that that those sightings were Aaron.
And you were asked why you didn't subpoena video from after June 4th. Why not?
Based on the information that we had when Aaron had went missing, we had no additional information to show that there was activity by Aaron that would have resulted at her residence or after. So we were focusing and trying to determine a timeline of when relevant information would be able to be obtained.
She was missing for about 2 weeks until June 17th.
Correct?
And you were asked if it would be easy to collect video during that time frame. Would it be easy to collect and watch all that video?
It would not.
Why not?
It would take a very long time. As I'd mentioned before, there's several video surveillance cameras across the city that we could collect hours and hours of video. It would take hours and hours to watch. At a point in time in the investigation, we were trying to determine how to find relevant information that would help us further the investigation. And that's why we are not able to obtain every piece of video from every surveillance video system.
That's all I have.
Recross?
Thank you. The video surveillance that you're reviewing, one person isn't doing all of that, right?
Typically not.
I think I counted more than a dozen different officers involved in watching video in this case.
That's correct.
That's standard practice.
It's very dependent upon the case that we're investigating.
That's something, but you can split up the workload, right?
You can certainly try.
Okay. And you realize that I watched all of the video in this case, right?
Now that you told me you did.
Okay. And that if you have 12 or more people able to watch, it's not an impossible task to gather additional video and watch it, right?
It's not an impossible task.
Okay.
However, they are doing other things at the same time.
And I understand that. So I want to talk about DNA swabbing just briefly. You agree with me when you're swabbing for what's referred to as touch DNA or nucleated cells, you're not swabbing every square inch of an entire facility, right?
Well, you're not, no.
You're sampling, right?
Yes,
Meaning that you're picking areas where DNA might be present and sending it into the lab, correct?
correct.
So in this case, there wouldn't be a need necessarily to swab an entire bed of the truck you could sample from areas where evidence might have been, correct?
You would take an educated guess on that.
Let's talk a little bit more on the information that was not provided to Dr. Reichard. You agree that you didn't provide him with information about the May 29th encounter with Irina Gebhardt, where Ms. Sambalai was saying that she wanted to die and was cutting herself with a knife?
Objection asked and answered, and testified to by Dr. Reichard.
I don't think it's asked and answer. Overruled.
You agree that information was not provided to Dr. Reichard?
I would have to agree that it was not.
You agree that information about Ms. Sambalai riding with her sister on May 31st, stating repeatedly that she wanted to die, was not provided to Dr. Reichard?
I don't believe that was provided.
You agree that information from Ms. Sambalai's brother stating that his last conversation with his sister, indicating she was in a suicidal state of mind, was not provided to Dr. Reichard?
Your Honor, objection, this is cumulative. It's been testified to by Dr. Reichard.
I'm going to overrule. These are the last statements that were made. There. Go ahead.
You
Correct.
agree?
Correct.
Okay. You felt that wasn't relevant?
I wouldn't agree to the statement that it wasn't relevant. It simply was not shared with Dr. Reichard amongst the information that was shared.
Thank you.
Nothing further, Your Honor.
Any questions from the jury at all? Go ahead. So I have a question for you. Was any further search done to locate the items Dr. Anzru described? And if it was, were they ever located?
The further items that Dr. Onzer described in terms of the kit, so to speak, or the clamps that were mentioned, no.
And they were never located, in other words?
No, they were not.
Mr. Grinke?
Were items other than rope important to the cause of death?
No, they were not.
That's all I have.
Go ahead, Mr. Zacher.
Sure. You know what? No. Thank you, Judge.
Okay. All right. So you may step down.
All
Thank
right,
you.
thank you.
Okay. Any further witnesses, Mr. Grinke?
No, Your Honor, the state rests.
All right. So, ladies and gentlemen, we sort of knew that this was going to happen, that we would only have one witness today. Unfortunately, the defense is not ready to begin today. We'll start Monday morning with the defense case. What I'd ask a couple things is remind you of that original instruction. I know I say this every single time, and I hope you don't get tired of it, but I do have to say it every time, which is please do not talk to anybody about this case. Don't let anybody talk to you. Don't look at any at the news. Don't look at the internet. Don't look at Facebook. Take a break from all of it. We probably all could use a break from the news nowadays. The other thing is don't let your curiosity get to you about looking at areas or anything of that sort. That's very important you don't, because we don't know what you know. Obviously, it comes back down to what you have to make the decision on is based on the evidence which is presented here in this courtroom. You've been great. I have no doubts about that. I just have to make sure you understand. If you do have questions, please let Bruce or Mary know, and we can try to follow up. If you feel like something is you're uncomfortable about something, please call us, or if you need to, actually you can call the police department if it's something that's really bothering you. Whatever you need, let us know, and we can try to follow up with that. Also, one other thing is, if you've noticed something you need this next coming week, I don't think it's going to be the entire week, but let us know and we'll try to provide it for you in the room. You can always do that too. All right, so have a good weekend. We'll see you about 8:45 on Monday morning.
Please rise for the jury.
Everybody may be seated. The state has rested. Mr. Zacher, did you want to, or first of all, Mr. Grinke, anything, I'm going to make sure everything was brought in by the state's evidence. I think we've moved for everything, all the different exhibits.
Okay, I believe so.
All right, if there's a problem, we'll talk about it next week if we happen to notice something that's not received. You know, it's all received. Okay, so it's all in. Anything further, Mr. Grinke, about the state's case?
No, Your Honor.
All right. Mr. Zacher.
Your Honor, I do have a motion.
Okay, go ahead.
Your Honor, at this point, I would move the court to enter a directed verdict of acquittal. The court's very well aware of the standard that the directed verdict requires, that viewing the facts in the light most favorable to the state, that a reasonable jury could not conclude that the evidence is sufficient to convict. In other words, that a reasonable jury could not conclude that there was not a reasonable doubt. And quite frankly, this case reeks of reasonable doubt. There's no proof that Mr. Sackett killed her. There's no proof that anybody killed her. I saw zero connection in the course of the evidence presented in this case that implicates Mr. Sackett in the death of Aaron. So I am asking the court to find that the state has not met its burden and enter a verdict of acquittal at this point.
Mr. Grinke?
Your Honor, Mr. Sackett said there was no proof that anyone killed her. The testimony at this point from Dr. Reichhardt is the cause of death is homicidal violence, which indicated by definition is death at the hands of another person. So there's clearly proof of that. The last person to see her alive so far in the evidence was her neighbor in the evening of June 3rd. There's no phone activity from Ms. Samvalai after the afternoon of June 3rd. The defendant talked to police twice and did not disclose that he was with her at her house on June 3rd. Hid evidence about the relationship that they had. There's a text message that indicates that Aaron Samvalai was going to talk to his PO and report him, or she was going to kill herself. He's then seen by truck traveling back and forth from the residence, corroborated by the fact that eyewitnesses saw him at the residence. She is then found in a lake that he has a cabin on, and she is found with concrete blocks attached to her that are similar in appearance to blocks found in the defendant's driveway. I think there's more than enough at this point to find the defendant guilty, or any reasonable jury could find the defendant guilty.
Okay. The standard was correctly stated by Mr. Zacher, which is looking at the evidence and most favorable to the state, that a reasonable jury could find the defendant guilty. I think that the state has met that burden, which is essentially, would it be reasonable for them to look at the evidence most favorable to the state without really, which really means you're not applying a high scrutiny of credibility or reliability on it. It's a very low level. And I'm not commenting on that, the level. It's just that it's a very, very minimal level. That's all I'm saying. Given that, the court will deny the motion for a directed verdict at this point in time. Anything further, Mr. Zacher?
No, Your Honor. Are we prepared to start at 8:45 on Monday then?
Yeah, 8:45 on Monday. And can I know this might be premature, but is there, do you have a rough idea, number of witnesses that you'll end up calling?
We're working on it, and we'll let Mr. Grinke's office know this afternoon.
Is it possible, can you let us know too?
Sure.
And is it possible we'll be done on Wednesday?
I think that's likely.
And I'm assuming the state doesn't know if you'll do rebuttal witnesses. I'm not at this point.
Not yet.
All right. Okay. I will, we'll see you Monday morning. Have a good weekend. We're in recess.